I think it's in order that I say welcome to the very last session of the day. And let me say that we do have a two-pronged topic for discussion this afternoon. I think we are all witnesses to the uncertainties that COVID-19 has brought. You have to take my mask off. That COVID-19 has brought to our world. And for us as lawyers, the question is, when we are about our practice in the courtroom, how do we do that in the midst of the social distancing, the washing of hands, wearing face masks, and so on and so forth? So the first topic for this afternoon will be the impact of COVID-19 on justice delivery, virtual hearing versus in-person advocacy. And the second leg of the topic will be maximizing client care in a virtual world. We have two very distinguished speakers this afternoon to do justice to the topic. And the first is Justice Vivian Amoah. Now, Justice Vivian Amoah was appointed a Justice of the Circuit Court in 2013. She was subsequently elevated to the High Court and is currently serving as the Justice of the High Court in Ghana. Justice Amoah obtained an LLB degree from the University of Ghana. She proceeded to the Ghana School of Law and obtained her BL certificate. She subsequently obtained an LLM from Illinois in the United States of America. She has certificate in ICB in the UK and IFM in the UK as well. Justice Amoah has been on the roll of lawyers for more than 20 years. She is fluent in French. She can read and write French very confidently. And not unimportantly, Justice Amoah is a proud member of the Full Gospel Business Fellowship, the East Legon chapter. Our second speaker for this afternoon will be Ace Anan Ankomah. And for those of us that are lawyers, Mr. Ace Ankomah needs no introduction, but I guess for the benefit of the doubt, we'll go ahead and say some few things about him as well. Mr. Ace Anan Ankomah is the senior partner and head of disputes of the law firm Bentsi-Enchill. He recently retired as the firm's managing partner. He has served on the International Chamber of Commerce Court of Arbitration and currently serves on the ICSID's panel of arbitrators. He is also a board member of Letsa. Now, Mr. Anan is a fellow of the prestigious Aspen Global Leadership Network. He has taught company law, taxation law, civil procedure, legal writing and editing skills, and Ace has several papers, published articles on law and practice, and I think Victoria has alluded to some, on the practice of law. He attended the University of Ghana School of Law, and he also attended Queen's University, where he obtained an LLM. So, ladies and gentlemen, please help me welcome our speakers for this afternoon. Now, we will invite Justice Ellen Amoah to speak first, and she'll speak for 30 minutes, after which Ace Ankomah will also continue. And because of the fact that the topics are related, I think it will be fair for both of them to speak, and after that, we'll take the questions. Thank you very much. My Lord, your audience.
Good afternoon, the President of the Ghana Bar Association, Ghana Bar Executive, His Lordship Nana Magache of the Supreme Court, the President of the Kumasi Bar, the National Secretary of the Ghana Bar Association, esteemed colleagues, ladies and gentlemen joining us through social media. Now, the impact of the COVID-19 on justice delivery. Next. Okay. Yeah. So the topic is on the impact of COVID-19 on justice delivery. Now I've titled this slide, bam, there it was. The discovery of COVID-19 in Wuhan, China threw a curveball at the world in March 2020 as legal systems grappled to deliver on their constitutional mandate amidst lockdowns. The future, it is now clear, was for the ready, the steady, the progressive, and forward thinking legal systems' ability to adapt to changing trends and exigencies was the key. The Ghanaian judiciary's march into the terrain of legal technological use was not propelled by COVID-19's impact in Ghana's judiciary. The policy of introducing change in legal service has been a feature of our service delivery from the days of the Justice Brobe retired fast-track court concept to the then revolutionary setup and structure of the commercial courts, and finally culminating in interventions like the e-Justice Project, web library, and virtual courts. These interventions were on course, due primarily to Ghana's commitment to the Sustainable Development Goals, which embodied access to justice and strengthening of democratic institutions. Now, as we speak, the drive for digitization of service delivery in key sectors, such as the legal fraternity, is also planned under the e-transform policy of the government of Ghana. Now, His Lordship, the Chief Justice, set up the Virtual Court Committee, headed by Justice Gbadigbe, which is a one of the direct and organic responses to the issue of how, or the conundrum of how to continue to deliver justice to the people in a manner that is COVID compliant. So the concept of the virtual court, or what is known in other jurisdictions as the remote court, was also explored here. At a pilot level, we had 15 courts across the various jurisdictional areas, and sensitization projects were carried out across all the 16 regions in Ghana, with the main goal of the virtual courts being 138 courts in future being earmarked for use of the technology. Now, the impact of the virtual court, now as you see from the slide, the notion of a remote court, a virtual court, appears to some to be difficult to conceive, but the mechanics and the use are fairly straightforward. All that is needed is a computer-enabled device. So it is either a mobile phone, as you see from the slide, a laptop, you have your wireless router, your tablet, or your desktop, and you are good to go. Now, for the Judicial Service, as part of the pilot project for the virtual court, cases have been trickling in on a demand basis. We have had interactions with the bar, we've had interactions with the Ghana Police Service, we've also had interactions with the prison service. This has culminated in these two email addresses, which I have slotted into this slide, that for those who want to use the virtual court COVID compliance services, you send an email to a dedicated email address, virtualcourts@jsg.gov.gh, or virtualcourtssingular@jsg.gov.gh. There is a dedicated IT team which handles all these matters. Now, the benefits of using technology in these COVID times is the fact that, and I've just listed some there, there is time efficiency, there is quick case turnaround time, there is cost efficiency, issues of traveling in and out, petrol, so on and so forth. And then the ability to be more productive, because online sessions are not supposed to drag on. Then I have put there applications, straightforward applications may be moved, and the whole pilot of the virtual court is not supposed to be used for trials. So it is for matters like bail applications, matters like interlocutory injunctions, straightforward applications, Order 7, Rule 6 applications, that is applications for substituted service, for example. There is no need to travel from Dodowa all the way to Accra as a court user when you can sit, receive a link at home through your phone or your laptop and join a court session and watch your lawyer move the application before the judge and watch the judge give his or her ruling. Another benefit of using virtual court technology and technology generally is the benefit it poses for case management. And I will not go more into that because a lot has been said by my seniors already. But there are some challenges which have been associated with the use of technology and the virtual courts system in the business of justice delivery. In some jurisdictions, though in ours we are yet to draw a line on that. Generally speaking, we do not fully highlight issues of demeanor. However, in other jurisdictions such as the US, issues of demeanor has become one of the topical issues associated with the use of the virtual court, with those judges who believe in that seeking to ascribe to themselves certain interpretative conclusions as a result of certain idiosyncratic mannerisms which they may cumulatively believe point to one's guilt or otherwise. These are highly contentious matters, but for us, primarily, the position ought to be that we follow the law. There is the challenge of witness tampering. That is text message coaching, etc. Imagine a scenario where a gentleman is giving evidence online, and the fear here is that whilst you can see him on the screen, he probably has a second mobile phone, and questions which are asked are then answers are provided by a third party, which may not be healthy for the evidence he is giving. Issues are also raised about sequestering of witnesses. When you are in the open, normal court scenario, you can ask a witness or a party to wait in the waiting room and be called later to provide evidence. But when he or she is online, you are not sure where he's waiting, who he or she is interacting with, and what is going on. There's also the potential of inappropriate access, and these are some worries that people have expressed in relation to the use of technology and remote court hearings. When Zoom started, we still continue to have the concept of Zoom bombing, where legitimate meetings all of a sudden were rudely interrupted by persons with other motives in mind, displaying portions of the anatomy which they would, under normal circumstances, keep under wraps. Then we have the issue of hacking as well, excuse me. And all these things, these disadvantages, especially the hacking, Zoom bombing, these things come about when you use the wrong software. In Ghana, with the virtual court system, we are using the same software as is currently being rolled out in the United Kingdom. We are using Microsoft Teams. And that is a software that sits on decades of technology and decades of privacy tightening issues. So we do not have issues of this nature in respect of the use of Microsoft Teams for the virtual court system. But there is also the general and a little bit pervasive, potentially explosive issue of unauthorized disclosure of personal records, information, psychological evaluations. And this has come about in jurisdictions where they have been using the virtual court for full trials. Like I say, in this jurisdiction, it is only used for straightforward applications. It is not used for full trials. So we are not there yet. There are some disadvantages which people have raised. Issues of data plans, the fact that people do not want to spend money to get the requisite data to sustain the connection, but the virtual court sessions last a maximum between 5 maximum to 10 minutes, even that. So it is not, it does not have that great a financial impact. And if a firm is running in a proper manner, these expenditures ought to be anticipated expenditures given the fact that the world is moving in a different direction. There are those who are cost averse. Anything at all is too expensive. These are some of the disadvantages. Some people also think that the technology is complex, and then there are issues of logistical constraints and the non-apparent clear ethical guidelines governing sessions. Now, in terms of logistical complaints, let me say that once you have a mobile phone and once you have an email address, you are onto the virtual court system. You can access virtual justice delivered remotely through the virtual court mechanism. Now, internally, in terms of ethics, I've just popped up some of the basic do's and don'ts, how to appear during a virtual court session. Appearance must be ethical in line with our normal ethics. Casual dressing is not permitted. The jury is still out whether one must be fully robed or not, but a decent suit and appearance that is in conformity with our ethical rules would be fine. Then what is expected for the virtual court? Connection at a place where it is quiet, where you can actually see the image of what is being reflected to you without the interference of outside noises. So these are some of the things. Now, I want to then briefly talk about legal challenges. Now, the interesting thing is that when COVID-19 struck, most jurisdictions started scrambling to see what can and cannot be done. Now, the example that I've picked is what has been done in Nigeria. Now, seeing that they are our brothers and we tend to mirror some of their principles, Section 36(3) of the 1999 Constitution of the Federal Republic of Nigeria, as amended, has a provision which mentions the fact that the hearings of matters should be held in public. Now, the challenge here is, what is the definition of public in COVID times? What does it mean in public? What are the implications for access to justice? If you are sitting in chambers, is it public? Can it be deemed to be so? It may appear to be rather obvious until you see the case of Oyedipo versus Ogundare, 1987, one Nigerian weekly law report citation has been cited there, where Obaseki JSC opined thus: when the court sits in chambers, all that it means is that the judges of the court are transacting the business of the court in chambers instead of open court. He made reference to the British case of Harmon versus Foster, 1881, 8 Queen's Bench Division. It does not mean that the court is not sitting in public. A court can sit in open court and yet decide to exclude members of the public other than the parties or their legal representatives from the hearing in exercise of its statutory powers. A judge may sit in chambers without excluding members of the public. It is therefore not unconstitutional to sit in chambers. Now, this decision was swiftly followed by another Nigerian case of Chime versus Ude, and the citation has been put up. And from that, the opinion is therefore that the apprehension whether remote hearings are in conformity with the constitutional requirements that the proceedings be in public ought to be allayed by the fact that the Constitution, and that is in reference to the Nigerian Constitution, did not say that such proceedings must be done in a physical structure called a courtroom. So once the proceedings in a remote or virtual hearing is made accessible to everyone involved and any interested member of the public, then the condition has been complied with, and that is the condition of access to the public in respect of virtual court sittings and virtual court hearings. Now, the enforceability of remote hearings and virtual courts has often been done in jurisdictions like the UK and Germany through legislation. And in Nigeria, they are actually waiting to go through their constitutional amendment. But whilst they are waiting for their National Assembly to conclude work on the bill to amend their constitution to give effect fully to and put to bed the controversy of whether or not virtual court is constitutional or not, the two states in Nigeria, the Lagos state and the Ekiti state, filed separate actions involving the original jurisdiction of the Supreme Court to interpret the constitutionality of virtual proceedings in courts in these two states all over Nigeria. And this was filed on Tuesday, the 14th of July, 2020. The Supreme Court came out with its verdict affirming that conducting virtual proceedings in courts in Nigeria is not unconstitutional. So we are yet to get any such challenge here in our jurisdiction, but this is what is going on so far with our neighbors. And these are topical and mind-agitating issues which we ought to be thinking about. Now, the next slide. The next slide, death by Zoom. Now, this is actually somehow a bit comical, but it is quite a serious matter indeed, because as with anything that is organically engendered, if you do not set bounds where there are no ethical remits, where there are no practice directions, where we do not have definitively do's and don'ts, it appears that the Pandora's box becomes opened and anything goes. Now, this death by Zoom highlights the most unfortunate circumstance of the Nigerian gentleman, Mr. Olalekan Hamid. Now, he is most unfortunate because he has become the first person in the whole entire world to actually have his death sentence pronounced by Zoom. Now, what happened was that the whole trial, in actual fact, was not conducted by Zoom, but due to the exigencies and the impetus for efficiency in justice delivery, the sentencing aspect was done by Zoom. Of course, we have the human rights proponents up in arms about this, and this is currently receiving a challenge by the Nigerian Supreme Court. So the long and short of it all is that the use of technology, virtual courts, is something that is supposed to help with justice delivery. It's supposed to provide fast, efficient, and financially financially expedient means of accessing justice. It makes use of technology, which means its applicability is wide. However, the other extreme of it is its unregulated nature. I have not talked about what has happened in other jurisdictions, such as the US, where even during virtual court sessions, some lawyers have turned up in their pajamas and all sorts of mind-boggling means of presenting themselves. So, in conclusion, the impact on justice delivery post-COVID-19 can be summarized with keywords: innovation and boundaries. Innovation, new ways of doing things, new ways of thinking about things, new ways of conceptualizing the notion of a court, a lawyer, representation, instructions to clients. Attitudinal change. The world is moving in terms of technology. One cannot remain fossilized in one's permanent position whilst the tsunami of change sweeps across the world. Luckily, the judiciary in Ghana has been innovative, has moved in tandem with the times, and have been propelled by its own protocols, agendas, and strategic plans. So we are at par in terms of the judiciary generally and how it is responding to the COVID-19 pandemic. The efficient use of technology and updated service delivery skills is one of the things also that comes to mind when we talk about the virtual courts and virtual modes of justice delivery. Court users are expecting more. They are more savvy. They are tech savvy. The previous issues of going to see your lawyer in chambers will soon very much become a thing of the past. It will all be done via the means of technology. And this also places different kinds of pressures on the various key stakeholders. Now, collaboration with the law and technology is one of the things that has come out as a result of COVID-19 and expansion of justice delivery. Now, post-COVID-19, justice delivery has adapted to achieve effective and seamless functionality without sacrificing on ethics principles and the intrinsic raison d'etre of the justice delivery system in a democratic society. So I think this is the end of this presentation. Thank you, please.
Thank you very much, my Lord, for that very insightful presentation. For our colleagues online, please note your questions down. And when Mr. Ankomah is done with his presentation, then we'll take all the questions. So, Mr. Ankomah.
Are you the president of
Thank you very much. Oh, this is what the president gave to me to use. Thank you. I assumed that I could see, and somewhat, pardon me for my height. Thank you. This is more like it. I'm going to be speaking with you. And look, if you come from my generation, it is very refreshing to hear a judge speak like this and mention the technical terms. I'm sitting there, I'm like, wow. But if you ever appear before Justice Amoah, this doesn't surprise you. I mean, look, allow me to tease her small. She's the only judge who memorizes citations. In her court, if you raise a point and she disagrees with you, she will tell you the case and mention the year. And if you are not lucky, she'll tell you the law report and page. Okay, so it's not surprising to see and hear how tech savvy that she really is in real life. I hope this works. I'm supposed to be speaking on maximizing client care in a virtual world. It works. What do lawyers do, essentially? 3 things. You resolve disputes, you advise on transactions, and you counsel clients on rights and duties. 3 essential things that lawyers do. Resolve disputes, advise on transactions, counsel clients. Now, I'd like to read this to you because this is Charles Dickens' interpretation of what lawyers do. You must read that book, Bleak House, just chapter 1, called In Chancery, where he starts describing lawyers. Now, this is what he says. On such an afternoon, some core members of the High Court Chancery Bar ought to be, as here they are, mistily engaged in one of the 10,000 stages of an endless course, tripping one another up on slippery precedents, groping knee-deep in technicalities, running their goat hair and horsehair warded heads against the walls of words, and making a pretense of equity with serious faces as players might. Now, this was written in 1853 about us. He continues, often on such an afternoon, the various solicitors in the course, same 2 or 3 of whom have inherited it from their fathers, who made a fortune by it, they are continuing the same case their fathers made a fortune on, ought to be, as they are not, ranged in a line, in a long matted well, but you might look in vain for truth at the bottom of it, between the registrar's red table and the silk gowns with bills, cross bills, answers, rejoinders, injunctions, affidavits, issues, references to master's reports, and I love this, mountains of costly nonsense piled before them. This is Charles Dickens' satirical description of us. In 1853, has it changed? Is this what lawyers still do? Still in the mountains of costly nonsense. But something has happened, and it's called the virtual world. As the practice of law emerged, and so has the practice of law emerged and evolved and survived from time immemorial. But this time-devouring megalosaurus of the law practice may have met its match in the virtual world. We've been the same. Everything has happened. We don't change. But the virtual world, which is this computer-based online community environment, which is designed and shared by individuals so they can interact in this custom-built simulated world, is beginning to present a challenge. It has always presented a challenge. It is in this context that the role of client care has become essential and the demand for client-centered practice. Allow me. Thank you. Client-centered practice. Oh, that's better. Now let's look at what law firm client service is supposed to be. News, it is not the product. It is not the service. It is not the victory in court. It is not the memo. That is not client service. That is the product. It is the experience. And so today I'm not here to talk law. I'm here to talk about the experience. And so it's the kind of experience you give to the client beyond the product, because you went to law school to deliver the product. So you can read the law, you can make the arguments. You may win, you may lose. What we are talking about is what was the client's experience. Now, this is a simple theory. Good service delivers happy clients or happier clients who bring more business. Newsflash, it is the experience or process is as important as, wait a minute, strike that, more important than the product. You can win the case and lose your client if your client service is bad. Yet, many law firms neglect or overlook opportunities to develop and improve the client service. You can take the mic a little bit down right now since I'm holding it, okay? Now, client service goes above and beyond doing the legal work. Doing what you had to do, showing you are the best lawyer they could have had, resolving the dispute, rendering great advice on the transaction, giving amazing counseling. Client service goes above and beyond that. Thank you. Now, let's consider, now you can bring it up a little bit. That's a bit too low. Now, let's consider the experience of a 2-star hotel and a 5-star hotel. The same result is that you want a place to sleep. So you go and you sleep, maybe have breakfast and get out. But the experience is different. With a 2-star experience, you forget the minute you check out. There's nothing to remember, hopefully. Now, there are 5 things about the 5-star experience. I said 4, but I lied, it's 5. 1, you remember. Because when you go to the room and you turned your TV on, you saw, "Welcome to Hotel ABC, Mr. XYZ. You are impressed. Wow, they know my name." Yes, they'll know your name. You checked in at the counter. They took your passport. But once they type in your word and assign the room, the computer puts your name on the TV screen. So you turn it and you take a picture of it and send it to your wife. "Akosia, look at me, I've arrived." The experience. You don't know you're paying for it. So you remember, you ruminate, you keep living it over and over. Then, because you arrive and there's a bowl of fruits. You haven't checked the price of the fruits, you see. It's like $2. But you see apples and everything, and sure, they are thinking about me. It is the experience. Then you return and you recommend. But the thing is that you pay a lot more for it. I'll give you an illustration. There are some airlines. You get in the first time you are flying a certain class. And we are going to use Mr. XYZ as the example and Mrs. ABC. And you sit down and the steward comes and mentions your name. "Hi, Mr. XYZ. 1, of course you bought the ticket. Of course you've been assigned a seat. It is seat 3B. If it's 3B, then you're in the front of the plane. So, and there are about 3 attendants attending to you. So one of them has been told to know your name. But you are impressed. You know that the thing is tricks, but you are impressed. So what will you have for, what drink will you have for dinner? You sit and say, "I like a Bucks Fizz. 70% orange juice, 30% champagne." Bucks Fizz, I hear, is a mix of orange juice and champagne. That's what I hear it's called. Bucks Fizz. It's a cocktail. Thank you. Hey. So they go and mix it and bring it to you. But when she goes to the place to prepare your drink, because they know how much you've paid for your seat, she types on the computer, "Mr. XYZ, Bucks Fizz, 70% orange juice, 30% champagne," entered. They bring it to you. The next time you board the plane, the steward will come and say, "Welcome back, Mr. XYZ. Do you still want a Bucks Fizz, 70%, 30%? It's a computer trick, but you are impressed. Let's look at this thing about mommy's birthday flowers. The story is told that Miss ABC forgot her mother's birthday. Around 3 p.m., she remembered, and she has the most cantankerous mother on the face of Earth, of the planet Earth, and many of us can identify with that, apart from me. Then she remembers her mother lives in another city. How is she going to send the flowers and the birthday card? So she goes online and finds a flower shop, calls them and says, "Please, can you send flowers and a birthday card to my mother at this address which is near you?" They said, "That is fine. It's just $20. She says, "Please deliver it soon, else I'll be in trouble." They said, "Don't worry. We will even apologize and say we are the ones who delayed it." She says, "Great." So the flowers are delivered. At 5 minutes past 5, her mother calls, "Thank you. These useless flower people, can you believe they only just delivered the flowers you ordered 2 days ago?" The next year, a day before her mother's birthday, she gets a call from the flower shop. "It's your mother's birthday tomorrow. Should we deliver flowers?" What have they done? They guarantee themselves a business every year. And what happened? When the mother died and she didn't informed them, they still delivered flowers. See, it is better to have one client who thinks you walk on water than having 10 who think you are just ordinary. Oh, and let me give a caveat. A lot of this I've learned over the past 15 or so years, attending seminars and courses, reading, and borrowed a lot from my client, my own law firm, what we do. So it's not, I don't really have the proprietary right to this. So don't quote me. I did one of these presentations. It ended up being quoted in a case. And meanwhile, I wasn't even sure the source of the information I put out. So let me put this caveat out right now. I'm so shy whenever I read that case. I'm like, do they know where I got this from? I don't even remember. Look, it's better that one client thinks you walk on water than to have 10 who think you are just ordinary. We must start matching expectations to delivery. The 2018 legal trend report, and I read this report almost every year, the 2021 is just out. It says that 42% of clients want to be updated on their legal matter every week. But how many lawyers think their clients deserve weekly updates? 24%. Actually, only 2% of us think that our clients need face-to-face meetings. Turning number. Hey, Mr. President, you're from Tadi. He knows turning number. But another book that you must read, The Client-Centered Law Firm, How to Succeed in an Experience-Driven World. Jack Newton says that the key to exceptional law firm client service is to make things easy for the client. Make things easy for the client. And he says you do that by accurately meeting expectations, delivering on needs. But watch this, in a way that makes their experience as effortless as possible. So you are not just providing good legal advice, you are making it easy for them to receive the advice, because that is what they've paid for, or that is what they are beginning to demand, especially in these days. And this I borrowed from my firm, that there are 5 key stages: client intake, commencement, matter management, financial matters, and closing. And for client intake, we are going to look at it from the request for legal service, conflict check, engagement. Commencement, we'll look at matter opening and assignment. Matter management, we'll look at updates, submission of the advice or conclusion of the matter. In financial matters, we'll look at submission of bills and following up on payment. Very, very important, client matter. And then closing is a client survey, file closure, and archiving. Client care is deliberate, I suggest to you. It doesn't happen by accident. It's not by chance. You must build the structures and systems. Your firm must have a client care charter. There are plenty on the internet. Please go and Google client care charter law firm. Plenty. Download about 10 and then sit down and say, I like this one. I don't like this one. I like this. I don't like that. And create your client's charter. We have one which says that if you're a partner and an associate brings you work, you must turn it around within 48 hours. Maximum 48 hours, you must send the work back to the associate. Can you imagine the turnover of work if you start implementing it? The partner knows that I must finish the work and return to the associate within 48 hours. I have found out that post-COVID, the clients don't even want to wait 48 hours. The client sends the response, the next minute they are sending text messages to your phone. When are we going to hear from you? Now, you must also anticipate the client's needs. Be agile, adapt. You learn something new, you add it to it. You learn something new, will it fit, will it not fit? You must also, now you may or may not share the client charter with the client. All the client knows is that they had a good, positive, and consistent experience. It's like McDonald's. Do you want fries with that? They've been taught that whenever the person makes the order, you should ask, do you want fries with that? It is their way of saying, do you want something else? Now, it is so beaten into them that sometimes all you order are fries, and they also ask, and do you want fries with that? Then, the problem the virtual world is having is that we have a profession that is still holding on to the brick and mortar mentality when the world has moved from bricks to clicks. That is one of our problems. So it's still the traditional street side law firm offering services to clients face-to-face in an office. I call it the hospital bench experience, where you come into our law firms and the people are really sitting on benches with the lawyer's door. So the one in front will go inside and the others will shift. And then the other one will go inside in 2021. we depend or are tied to a physical location. We are reliant and over-dependent on tradition and history, hard copy textbooks, notebooks, and pens. So one lawyer told me, as for this, your computer thing, I don't like it. I like to carry the books. The weight of the books makes me feel that I know the law. Physical files, poorly kept, and source of all updates and adjournments. We see ourselves in court. We have a way of keeping the files. We fold them as well into 4 parts, and you write the next adjourn date at the back. Nothing about what happened in the court, what the court ordered, nothing, just the date. And so what if you forget? What if, and some of the files have seen better days. They are flail, they are tearing. We are still writing behind them. We love it. We love the books. Then we come to accounting. We are still taking cash in COVID. Now, if you take cash, you have to spray it. People are still writing checks. I'll tell you what, I still write checks, and my wife works in a bank. So I ran out of check leaves, and I applied for a new checkbook, and they brought me 2. Then when I said, oh, your wife asked for a check about 9 months ago. She hasn't come for it. So I'm like, but you too? I said, I haven't written a check in over a year. It's not necessary. Everybody has a mobile phone. If you have a mobile phone, she can transfer money to you. If you have a bank account, she can transfer money to you. But she has told the people, if you don't have an account, I won't pay you. So why is she writing a check? She's only limited to, let's say, 2,000 a day. And of course, the way she is, she's happy that she has a limit. Let's move quickly along. My time is almost up. So the virtual world has moved us into not just digitization, but digitalization. I spoke about this at the last time I spoke at the Bar Conference. I'm not going to go over it anymore. But don't just digitize, you must digitalize. There's a distinction. Then enter the catalyst COVID-19. Whether you like it or not, its most direct impact is the lack of or reduced physical contact. That is why this room is empty. And it's just a few of us with social distancing. We are wearing wigs and masks. Face-to-face meetings have now become life-threatening events. So if you insist that, as for me, I need to see the client's face, the client may kill you. You may kill the client. Murder. Intentionally causing the death of another person by unlawful harm. Now, so we are forced into rethinking, redefinition, recalibration. Question, is work a place or a thing you do? I did not know that I could give legal advice in my pajamas, as long as I don't show the picture. I didn't know I could think legally. For almost 30 years of my profession, I'm in the office by 7:30, and I leave after 8. I must be in the office to meet the team that is going to court. Is there anything? Hey, have you checked the last case? Okay, hey, we are late. Let's run to court. Come back. Fast. Hey, now I couldn't come to the office. And I realized that, I don't even need the physical files anymore, because I can still have access from wherever I am and still work. And it's faster, and it was quicker turnaround. Sitting in my chair, less stressful. And I also found out about church. You leave home, go to church. After church, you stay in meeting 1, meeting 2, meeting 3, get home after lunch, hungry. Now you sit in the same chair, you watch your pastor and 5 others. 5 others, free. Anyway, I digress. I don't have time. Is the court, and my Lord is right, is the court a place or something you do? I want justice. So there's the indispensability of technology. The less our tools depend on or are tied to a physical location, the better our chances to survive or even thrive. The use of and reliance on the virtual world has become indispensable. Now, let's start with all of these. Let's start from the client intake and onboarding. So there's a request for legal service. The days of the physical walk-in client are either gone or numbered. It's noticed to you. They're either gone or numbered. I don't remember the last time I met a client physically. Last year? Well, some might pass by, insist that they want to come in. Then I told you that we have protocols. So you come in and we are masked. So I don't even see your face. I don't even know whether you are the one you say you are. You don't even know whether I'm the one I say I am. But more and more instructions are coming in by way of emails. Yes, sir, your name has been given to me by such and such a firm. We have this matter in Ghana. Kindly indicate whether you are able to take it for us. Then your next step, we'll go to the next step. Even client meetings and conferences are now on online platforms. Within the firm, We have banned physical meetings of each other. So if you have a meeting within the firm, like I had a finance committee meeting yesterday, we are all sitting in our offices working by Zoom. Yesterday, I taught a class, a continuing professional development in writing skills in the firm. Everybody was sitting in the office. You just check in on Zoom or Teams or whatever we choose for that purpose. So even within the office, and we have that huge conference room up there, and all the meeting rooms, they've been rendered useless. We have just furniture sitting there. Even the meetings, touch that thing for me. It's my 2:30 alarm. Thank you. Conflicts check. Now, you can know from LI 2423 that they are looking for us on conflict. On conflict. So you have to ask yourself, it's not just professional conflict that you worked for the client before or you still work for the client. Even social conflicts are important. Do I know the director? Have I had lunch with a lady there before? Do I know somebody in the opposing establishment? You ask who are the names of the principal characters. So, and then you send it around your partners. These people have instructed us, please, does this ring a bell? But that is just the human memory. How are you going to remember your clients after 3 years? You will forget. That is where the virtual world comes in. You also have to look at the kinds of conflict. Is it not significant, stroke generally permissible? Is it potential or perceived? Is it actual? Previous engagement with any of the parties or significant principals? What institutional memory are you relying on? Human recollection? You will forget. Is it an analog filing system? You will lose information. So you must begin to digitize your client information. Hire somebody just to, even if it's just the names and the file numbers in a Word file, at least you can do Control F, which is find, and type the name before you get embarrassed because you just can't remember when you've had a certain number of clients. Comprehensive engagement letter. The General Legal Counsel is telling us that if you don't have one, you won't be paid. Are we still insisting on signatures? If I send an email, the clients have been communicating by email. I say these are the terms. The client says approved. We have an engagement. We have an engagement. Now, so confirming emails should be acceptable. Electronic letterheads are the thing now. The major law firms are using it now. There's a rise of electronic signatures. So I am not in the office. The thing has been, they called me. It is passworded. So I tell the PA with whoever is there, this is the password to my e-signature, or send it to me. I apply the e-signature in my house. Then I save it, I export it to PDF. It's just a click of a button, ladies and gentlemen. You cut, copy. Me, I'm old school. So copy is Control C. So you highlight Control C. I know you want to use the mouse and Control C. I bring it down, Control V, paste, shape it. I won't give it to my PA in a way that can be lifted. So I export it from Word into PDF. Please, it's a click, export, PDF, save. It goes back to him or her, and it goes to the client. I don't have to drive to the office to sign. The days where we signed checks of this mountain are gone. They'll bring you if you like a printout, you get it. But they email the list to you. The bank link comes up. You take your tongle, enter the card, enter the number, enter your number, whatever, PIN and other numbers. It's open. You check. The numbers are the same. Click. Bam. Everybody's paid in the office with one click. You do your cross-checking and post. We have all verifications, post verifications, send it back. In 5 minutes, everybody's salary is paid. In 5 minutes, the client information has left. Then there's a commencement, matter opening. Still, you need to create a physical file because we are still filing papers physically. But you must also create the electronic file in which matters will be saved. You must link the two for both accounts and the law. And then you communicate to the client, on this day, we have opened your file. Matters have begun. Our representation of you begins on this day, which is usually the day the client signs on the engagement, formally. So the client didn't say, you didn't do something 2 days. As I said, the 2 days before, you hadn't engaged me. You hadn't signed, and you hadn't paid. And there was a client who wanted to make a complaint that we didn't start the matter early. But because you kept records, you say, wait a second. I sent you the draft engagement letter on this day. You did not acknowledge it until that other day. And this is the day we told it, and that day we told you we had started the matter. Anything that happened before then was not because I hadn't been engaged. Had we not had those records, that client would have been might have been right. So you inform the client by e-communication. Then you assign to a lawyer. When you assign, please tell the client, communicate. I've assigned lawyer BCD and EFG. BCG is a senior associate, EFG is an associate. Most of the lifting will be by the associate to reduce your cost. The other one will do it. I take the final look at it and I appear in court during the trial. You set it out and communicate with the client. 2 years ago when I spoke at this conference, I had a theme. I said, clients are bad, oh, clients are bad. Not all the time. But if you don't cover your tracks, one, covering them makes you more professional. Two, it makes sure that if there's a protest, you have a paper record. So you know when you are wrong. He said, look, I erred, I confess, right? Please keep staffing to a minimum, no substantial changes without consulting the client. If the lawyer who is doing the matter leaves the firm, tell the client immediately. Because clients are unhappy when today it is Mr. XYG, the next day it's Mr. CDH or Madam CDH. The client is the step. Please notify them of that. Matter management. You must keep the client, 5 minutes, I'm done. 5 minutes, I'll finish through. Consistently apprised in reader-friendly language. Please, that our language has to stop. In witness whereof the parties hereon to have set their respective hands and seals on the date and year first above written. You simply mean signed on. And the document will lose no legal value if you say signed on such and such a day by so and so. And you think, some say to me, but how would they know I'm a lawyer? You are not offering service. It must be reader friendly. I'll move on. And how we lost a client? I'll tell you. We lost a client and we didn't understand. Years later, the law firm they went to, I met one of them and said, oh, look, when we read it, we were so happy. You are done all the work. Oh. We didn't change anything. We just continued what we had done. I said, so why did you leave? He said, you are not talking to them. We're not talking to them. Financial matters. There's the virtual practice now means that there's a rise in alternative fee arrangements. Begin to look for them because especially your foreign clients are no longer accepting your basis of billing. They're going to come to you with alternative arrangements because they are virtual and they expect that some quality of the services will change because of that. I just want to highlight that to you. And send the bills as agreed and chase the bills. Lawyers, chase the bills. I can assure you that if every lawyer here assigned to me and paid fees, I'll be a billionaire in one day. Chase the bills. Set an Outlook reminder. Every Monday you send a reminder. The next Monday you send a reminder. Then you tell them this is getting to aging account. At this stage, I will not appear in court again. Please, if you can't chase the bills, assign them to me. I won't work again for the rest of my life. Oh, and then payment. Checks and cash getting out of vogue. There are card payments, direct bank transfers, even Momo exists. You are not too old to receive electric payments. Closing of the matter. Client surveys, every 3 years you must do it. At the end of the matter, do client surveys. It's email. You send it to them. If they don't send it, it's okay. But you must do your client surveys. There's archiving, close the matter. And when you're finished, let me give you a tip. Every Christmas, send the former client a Christmas card. Every Christmas card. Don't ask me why. Concluding comments. We have prided ourselves on tradition and safety, but we are in the information age where information is a commodity, is widely disseminated, and is easily available. The world has changed. We need to change. Virtual law firms exist now, and virtual practices. I will tell you a secret. We broke off in March last year. There are partners and associates in the firm I didn't meet till we met at the funeral. They are home, just on their laptops, and they're doing everything they're supposed to do. The virtual practice has started. It cuts down expenses. We must begin to change to meet the times, especially when the clients are demanding it. There's no need for panic. Bit by bit, step by step, improve, and we'll go on. Shakespeare said something about us. Dick the Butcher said, the first thing we do, let's kill all lawyers. Thankfully, Tranio said in Taming of the Shrew that let's do as adversaries do in law, strive mightily, but eat and drink as friends. In the end, it is important to remember that we cannot become what we need to be by remaining what we are, Max Dupree. And then Sam Leveson asked, don't watch the clock. Do what it does. keep going. Thank you very much.
Thank you very much. Thank you very much, Senior. I suppose that we saved the best presentations for the last session. So thank you very much, Justice Ellen Vivian Amoah, for that insightful presentation once again. And Mr. Ankomah, thank you so much, for that, thoughtful presentation. I think we'll go ahead and take some questions, and then we'll bring proceedings, to a close. So if we can have the questions pop up. All right, so the first question. Okay. Great presentation. So this is from Ernest Ose Afo. Great presentation by Justice Ellen Mensah, Justice Ellen Amoah, and their presentations are awesome and surely the way to go. How do we get our courts outside Accra to function with speed in a virtual world? I've had the trouble of traveling to Kumasi, Takoradi, and Sunyani on several occasions to be told the courts were not sitting. Can we get the court to think more as a service delivery institution? Example, notifying counsel and parties of impending schedules and adjournment to avoid unnecessary costs and delays as expected under Order 1, Rule 2 of CI 47. So maybe Justice Amoah will take the first bite, and then Senior Ace will go ahead and continue.
Hello. In respect of how to get the court to think more as a service delivery, it's an organic project. It has been going on since the inception of the judicial service. You agree with me that the judges, court users, and lawyers that we have now are not cut of the same cloth or ilk as our predecessors in terms of technology and in terms of being responsive to societal needs. I think the example about courts not sitting without notice is rather unfortunate, and it is actually not the trend, because indeed and in fact all duty conscious judges, whether they have a training program or an absence that is usually authorized by the judicial secretary, would have notified their court staff of this state of affairs. With the advent of social media and the work that has been done by the Ghana Bar Association in terms of interacting with the bench and the bar, there is nothing that prevents a particular court to send a notice with the approval of the bar if a particular matter will not be heard on a particular day. And I myself, I have liaised with the Miss Susanna Nyampong of the Ghana Bar Association on several occasions where events were supposed to have been events were supposed to have taken place, but for one reason or the other could not come on. We did not leave the members of the constituency bereft of information. They were fed with the relevant information. So I think this is a rather unfortunate example, but it is by no means a general example of the state of affairs of the judicial service and the judges in terms of their focus on service delivery and the new exigencies that have come about.
Thanks, Your Lordship. That's clear. And it can be very simple. It could be very simple. And sorry, I keep using my daughter as an example. The first day you enter her court, she will ask you to leave your phone number. Every lawyer. So at least the phone numbers of the lawyers can be on the dockets. It's very simple. Everybody uses a mobile phone now. How much money was transferred through mobile phone? 500 billion last year. It shows the number of people who are using mobile phones. So if the court can't sit, the clerk can just send a text to the lawyers. My lord can't sit today. Please, let's agree on an adjournment. It's very doable. But we, the lawyers, also ought to assist the court in this regard. I was before a court in Kumasi, and we needed to hear the matter quickly. So I suggested that when I have sent for when they are going to file, can I serve my learned friend, will you accept my email version? So that even before it's filed, you see it. So you start preparing. He said no. But I believe that even at case management and even at the beginning of the case, lawyers can agree, exchange email addresses, exchange phone numbers. It is not formal service, but I'm giving you notice ahead of time. So you know what I'm filing before you are served. But the lawyer will still, anyway. But so we ourselves, we are our own enemies in this regard. But yes, it is doable. And it's between the court management system and the bench and the bar can easily agree and do these things without the inconvenience.
All right, thank you very much. Can we have the next question? Her Ladyship, this is from Agbenu Do. Her Ladyship, Justice Ellen Amoah, is always on point. Excellent delivery. How do law firms sign onto the virtual courtroom concept? Do you have to scan all your files and upload them onto the virtual platform, or the court will have to do it will do that for you, essentially? Yeah. Well, my lord, I don't know if you want to do that, but it appears to me that this is more from.
Well, I mean, no, the court, I mean, you seriously want the court to scan your documents for you. I mean, nobody's going to do that for you. Yes, you want to upload, you sign onto the system, you upload from your office, and you make sure that it's properly uploaded and it's gone into the system. You do it. And you see, now scanning is not a big deal. Your mobile phone, scannable. And it's there, it's PDF. You choose the format and you send it. So you can do it yourself and just upload it, and you are gone. But it's a question you're repeating because my lady gave the email addresses. You can access the e-justice system and use that way. I still get notifications. There's one particular case that they still send me emails on about 2 or 3 days before the hearing. I still get it consistently, and then it's a reminder that we're going to go to court. So it's doable, absolutely.
Can we have the next one, please? Okay, so this one is an anonymous attendee. All right, so how much investment is required to digitize a law firm? What is the necessary first steps? What are the setbacks and mitigation strategies? This one is, do you want free advice? I have to help.
Which 2018, I had a whole presentation on this at the bar conference in Koforidua. I can't give you a figure. It starts with your mobile phone. Stuff. The mobile phone in your hand is literally almost all the information. The mobile phone in your hand is virtually all the information in the world. It's the start. One of the ways I coordinate my team is that we have a simple WhatsApp platform for all the minutes that we use. So if I'm cross-examining someone for, and another case is coming up, I find time to type. Can anybody go to court and cover for me? Somebody says, oh, I'm in court, and please go and cover for me and take an adjournment. So there are ways in which you can do this by starting from that. Then your own laptop with the office suite is your email station. It is your diary. Whatever, and your phone is your diary. Every phone has a diary. It's called the calendar. You can enter your court date, and you can set an alarm that 24 hours before the court date, remind me. So actually, the future began yesterday. The problem is that anonymous attendee is already late. The future started yesterday. And so every electronic gadget that you have in your hands can enhance your service. Then there are additional issues, the law databases, the artificial intelligence uses. That is further down the line. Like I said, it doesn't come in one fell swoop. Supermen don't leap over a building. No real Superman or Superwoman leaps over a building in one fell swoop. It is taking small steps consistently over a period. That is how come Supermen and Superwomen evolve. So you start from there, you hear of something, you buy it, you use it, it works. You hear of another, you talk to a friend and you use it and it works, and you develop. So start from your mobile phone. You can manage your practice from your mobile phone without missing court dates. Very doable.
All right, thank you. So I guess that you said that the future starts yesterday, but it continues today.
Yeah, absolutely.
Yes. So anonymous attendee can
start now.
Yeah. Today. Yes. All right. I'm glad to hear this. In Tema, we had to appear in court without any notice that the judge will not be in court that day. We asked the court clerk, who told us that they were not supposed to contact parties in court. So how do we get the court officials to do same? My lord, yes. I mean, this one, obviously, you have to be, of course, the attitudes. And I suppose, my lord, do you want to say something about that, or you want me to? Well, I suppose that, of course, when all of us we end up in court, we make sure that, as much as possible, we have very good relationships, with, the courtroom officials, essentially. And sometimes they also become very important sources of information for us to know. And I say that oftentimes it's good, as a practitioner to yourself, make the effort to find out, from the courtroom officials, what the business of the day is. Because there are instances where, all of a sudden, people are taken ill or there's an emergency of some sort. And when you are proactive yourself, then you don't have to drive all the way from your house, to get to the courtroom. All right, thank you. Frederick Gura Sampson, great thought by Ace. From my training in law school, maybe legal ethics and advocacy, there's no conscious effort to train on client care, that is customer service. I believe a conscious effort must be made in this regard as part of our training. Client service is key, for our practice. I think this is more of a comment, than a question. Are there any? Okay. So, Mr. Sampson.
Of course, but I think it's quite recent. Yeah, so those of us who left school a long time ago. So maybe we should, the new lawyers we hire should be teaching us. So maybe Mr. Sampson, hire one of the more recent graduates, they'll teach you. Oh, okay.
It's currently being taught.
It's currently being taught, yes.
All right, good. So I think that will be all for this afternoon. And I will hand over to the organizers, to go ahead and conclude the program.
Thank you very much, Dr. Ainuson, Justice Ellen Vivian Amoah, and Mr. Ace, Anan, Ankomah. We now invite the National President, Mr. Anthony Folsom Jr., to give us the closing remarks.
My Lord, Justice N.A. Amagache, former president of the Ghana Bar Association, our colleagues in here, and those who joined us virtually, I've been called upon to fill some very, very big shoes. This should have been done by His Lordship, the Chief Justice. He delegated the authority to His Lordship, Justice Bafo Boni, but he could also not be here, so I'll have to fill those shoes. Now, I'll quote Mr. Ace Ankomah with his permission, what he said in September 2018 in Kofredra, that the future started yesterday and we are already late. Luckily, over the 2 days, we've seen the importance of technology in a virtual world. We've seen how we can manage our practice by adopting technology. And we've had assurances from the Honorable Attorney General that the Attorney General's office is also going virtual. The Bar Association has done its bit, and we believe that by the end of my term in September, we will be ready with the CLE solution, importing some technology from the Republic of Czechoslovakia. We believe that the dictates of LI 2423 relating to continuing legal education, even though some have said that the Ghana Bar Association is a voluntary organization, we don't mind. We'll make sure that our members are abreast with the dictates of LI 2423. If you choose not to be a member of the Ghana Bar Association, that is your choice. We've had excellent speakers over the 2 days. Indeed, if you look at the participation of this event, you see that it far exceeds what we have had with the in-person events. All the speakers have been excellent. Indeed, we thank all of them. My Lord Justice Amegache, you know you cannot run away from the bar, so, well, we are always your children, and we are always thankful for your support. We thank especially the court manager and the judicial secretary for your assistance in giving us this place and your support over the years whilst I've been president. We are very, very grateful. We thank our participants who joined us virtually, and we hope that when we meet you in Bolga in September, this will be a very special conference because it will be an election year, and we are going to make sure that we will have both types of arrangements so that those who cannot come physically will be in the virtual space, but with the caveat that you'll have to pay your conference fees before you can exercise your franchise. So people will be able to exercise their franchise from their offices, from their homes. So we are going to have a very massive turnout in this year's elections. From tomorrow, all the presentations will be available on the GBA portal. So once you are paid up, you can go onto the portal and access the presentations. We've had an insightful lecture on social media, which is the current trend. It is obvious that regulation in that space is so difficult, but we hope that with time, we'll all be able to regulate ourselves, and if it is a matter for Parliament or whoever is in charge, we'll be able to deal with the menace of social media. But definitely it is also a useful tool for the dissemination of information and friendship between lawyers. We thank Professor Bonzi Simpson, who, despite his bereavement, took time to give us the keynote lecture. And once again, I will express my profound thanks to the organizers of this program, Mrs. Jacobo, whom I would advise that you should start grooming somebody to take over from you, because obviously there's so much information in your head and you'll have to pass it on. I thank the National Executive for putting this together, all the regional executives for coming, and God bless us all.
Thank you very much, National President. And I would just like to make Mr. Ankomah very happy this evening. We all know what happened in 2018 in Koforidua. And for the records, for yesterday's opening ceremonial plenary session, we had 531 people, 531 participants joining. And we had 337 in the afternoon. And for this morning, we had 408 on Zoom, 35 on Facebook. And for this session, 344 joining on Zoom, 23 on Facebook. And it looks like the future started at Koforidua for us. And it's continuing for us. I'd like to thank everybody. And as usual, we have our national PR, our director of bar protocol. And now, oh yes, I hear that, you see, one of the beautiful things about the bar is that I always say that people think lawyers will go to hell, but will go to heaven more than any other profession. The national vice president also happens to be the president of a lay president of the Methodist Conference. Yes, so invite National Vice President William Odru and President William Odru to give us the final anointing for today.
Thank you. Yeah. The president, I proceed. Let us pray. Let us pray. Father, we are most grateful for this day. We thank you for the institution of the bench bar faculty lectures and for that matter conference. We thank you for this year's edition, and especially the topic, professional development, looking at the virtual world and also emerging trends and best practices. Father, indeed, you've given us resourceful persons to tackle this topic. And indeed, we are most grateful. We thank you for the participants in person and all those who participated virtually. Indeed, the COVID has also taught us a lesson or two as regards what we can do in our difficulties. The numbers that participated speaks volumes about the positive side, even in this pandemic. We are most grateful for this particular institution, the Bench Bar Faculty Conference. It's our prayer, the Lord, help us to deepen this particular conference so that we use it to teach ourselves and move on, even as we are moving from yesterday. Father, we thank you so much. Those who came, Father, I pray humbly that you grant each one travel mercies. And those of us who watched or participated virtually, bless us wherever we find ourselves. It's my prayer, Lord, even as we listen to these talks, these important talks, give us the grace to implement them so that the bar, the bench, and the faculty together will move the administration of justice forward in this country. This country is blessed to continue to bless us even as we implement these things that come our way. Once again, continue to bless our resource persons so when they are called upon to deliver, you continue to teach us. We ask this and many more through our Lord and Savior Jesus Christ. Amen.